Hello everyone, and on behalf of ANROWS, I welcome you to today's webinar, Family Law Parenting Orders, Breaches and Their Impact on Children. My name is Michelle Robinson and I am the Director of Evidence to Action at ANROWS. I acknowledge the country on which we meet today. I am coming to you from the lands of the Gadigal peoples of the Eora Nation. On behalf of ANROWS, I pay respect to elders past, present. Wherever we are today, we are on unceded Aboriginal and Torres Strait Islander land. And I acknowledge and pay respect to Aboriginal and Torres Strait Islander people joining us in the webinar today. In today's webinar, we'll first hear a presentation unpacking the latest evidence on parenting orders, compliance and breaches. And this will be followed by a panel discussion and Q&A. Before we start the discussion, I would like to draw your attention to the toolbar located at the top of your webinar platform. This toolbar will help you navigate your way around the webinar. The dark blue hand icon will allow you to submit questions to our speakers. The light blue arrow icon will allow you to download today's supporting materials, of which there are a few, and the green icon will allow you to refresh the page if you experience any issues. The webinar will be recorded and it will be available on the ANROWS website as soon as possible. You can subscribe to Notepad, our e-newsletter, to be notified when it's available, which should be probably within the month. Finally, we have a survey that will pop up as you exit the webinar. If you could take a couple of minutes to complete it, we would be really appreciative of your feedback. Your responses will help in ensuring and improving ANROWS webinar program. This is a confronting topic and some participants may find it depressing and disturbing and distressing. It is important to take care of yourself while watching the webinar. If you would like to access support, please contact 1800-RESPECT, 1800-737-732 or Lifeline on 131114. So today we are launching the second and final report of the research study on compliance with and enforcement of family law parenting orders. This important study has been conducted by the Australian Institute of Family Studies with funding from ANROWS. The research examines how parenting orders and the enforcement regime is working in Australia. It analyses the drivers of non-compliance with these orders, including the needs of children and young people, and concerns about family and domestic violence and safety. It is important to note that during this research, a new court structure took effect, replacing two separate courts with the Federal Circuit and Family Court of Australia. Other changes, including a new national contravention list aimed at triaging and assessing contravention matters, was also introduced while the research was underway. The research provides an evidence basis for future reforms, including providing a baseline against which the impact of any future reforms can be measured. Now I'd like to introduce you to the panel. So today's presenters, I'll start with Dr Rae Kaspiew, Research Director, Systems and Services from the Australian Institute of Family Studies. Welcome, Rae.
Thanks, Michelle.
Dr Rachel Carson, Executive Manager, Family Law, Family Violence and Elder Abuse, also from the Australian Institute of Family Studies. And Rae and Rachel are the researchers who have finalised the study and led the report writing. I would also like to introduce Dr Heidi Saunders, clinical psychologist, Carinity Tulera from Queensland. And on my left, Donna Smith, Acting Solicitor in Charge, Central Sydney Family Litigation from Legal Aid in New South Wales.
Thanks, Michelle.
Welcome, Donna. Michelle Hayward, Managing Solicitor, Family Law Practice from the Aboriginal Legal Service, also in New South Wales and the ACT.
Yes.
Welcome, Michelle. And Gabrielle Craig, Assistant Principal Solicitor from Women's Legal Service here in Sydney.
Thanks, Michelle.
Welcome, everybody. So today we are launching the report, which sets out and seeks to help us understand how parenting order enforcement regime is working in Australia and the impact on children and families. It has been a long journey. The research was commissioned in 2020, and in that time we have seen many changes to the court, to court practice and process, but also it was conducted during COVID. Began before COVID. Ray and Rachel, can you tell us more about the research and the journey that you've both come along?
Thank you, Michelle, and thank you to ANROWS and the Department of Social Services for funding this very important work. I also want to thank all of the parents and carers who participated in our survey and the other stakeholders who supported the research, including by participating in interviews and surveys. I also must acknowledge the Federal Circuit and Family Court of Australia, which gave us access to files on which one component of this work is based. In broad, it's actually wonderful to be here with such an expert panel sharing the findings. As Michelle has indicated, it has been a long journey. It's been a complicated piece of work, as you'll hear when I talk about the methodology. And we, of course, had to contend with the complexities of COVID, which made some of our data collections much more complex than they would otherwise have been, as well as presenting complexities for the parents and families who have parenting orders, and we also looked at that in this research. In broad terms, as Michelle has indicated, the research was set up to look at the drivers of non-compliance with parenting orders, how parents respond when non-compliance occurs or breach occurs, and how the enforcement regime is operating when parents do go to court in relation to contravention applications. Our project had 4 parts. We did an online survey of 470 parents and carers who had parenting orders made after June 2016. Many of those parents and carers had settled their litigation through making consent orders, but around a third also had judicial determinations. And so that is a group of parents who had embarked on litigation and were some way down that pathway, if not making it all the way to judicial determination. We also collected data from 300 court files involving contravention applications, and we collected data from an additional 147 judgments where contravention applications had actually proceeded to judicial determination. In addition to that, we did a survey that 343 professionals across the family law system and also including the family violence systems responded to, and we got some very valuable insights about the way that professionals view these questions. In addition to those 3 empirical aspects, we did a desktop analysis of approaches to contravention in England and Wales, in New Zealand, and in the US state of Michigan. We learnt a lot about the factors that underlie non-compliance with parenting orders from this project. Both our survey of professionals and our survey of parents and carers demonstrate that 3 main drivers of non-compliance are concerns related to abusive, controlling or vindictive behaviour, very difficult relationship dynamics including fear, family violence and safety concerns, and orders that don't suit the needs of children. In relation to relationship dynamics, it's significant that of the 470 parents and carers that responded to our online survey, 37% of women and 20% of men described their relationships as fearful. This compares to 7% in a representative sample of 7 separated parents. So it's very clear that's what's going on in these circumstances are very, very complex relationship dynamics that mean that children are growing up in quite difficult circumstances and that parents find it challenging to engage in the level of communication and cooperation that's required to successfully implement parenting orders. When we asked our participants in our online survey of parents and carers whether their orders had been breached, 88% said they had, and 80% indicated that this non-compliance should be considered serious. However, as we explain further later, most parents don't take action in relation to non-compliance. Overall, the findings of the research indicate that there's a group of children and young people with parenting orders that don't suit their needs. What we learned in relation to court use was that in circumstances where contravention applications are lodged, this is often associated with a very intense litigation history, not only in relation to the contravention applications, but in relation to the prior parenting proceedings. Almost 6 in 10 cases had 5 or more parenting or contravention applications. More than 1 in 10 had 10 or more. There was an average rate of 6 court processes across the sample. Often, these families were in court for substantial amounts of time. The mean overall duration from the start of the parenting matter to the end of the contravention application in our sample was 54 months. The mean duration from the start of the parenting matter to the contravention application was 36 months. So some fairly significant time frames, as well as intense litigation activity is involved in these situations, and it forms the backdrop to the way that the children in these situations are growing up. It's notable that the vast majority of matters had allegations of family violence and or child abuse, more than 90%. And 55% of those cases involved cross-allegations, that is, circumstances where each party is making allegations against the other. These findings are concerning from a child-focused perspective. And Rachel will tell you more about this.
Thank you, Rae. Our survey of parents and carers provides significant insight into the wellbeing of children for this cohort of families. And these child wellbeing outcomes were reported by parents and carers in the survey, and they are cause for significant concern. They show that 45% of parents and carers said that their children or child were doing somewhat worse or much worse in most areas of their life compared to other children of the same age. This is much higher than reports from a representative sample of court-using parents in our Experiences of Separated Parents study, which formed part of our evaluation of the 2012 Family Violence Amendments, where only 12% of those parents reported that their children were doing worse or much worse than other children of the same age. These findings raise significant concern about the well-being of some children who are subject to court orders. And when considered together with the findings that Rae mentioned earlier about intensive litigation history and the relationships characterised by fear and domestic and family violence, these findings illustrate significant concern for the child wellbeing in this particular cohort. Additionally, our contravention court file data identified information on court files indicating 36% of cases involved children with special needs. And these related to learning needs, mental health needs, or involving physical or intellectual disabilities. In this context, it's not surprising that enhancing children and young people's participation in the decision-making process about their parenting arrangements has been identified by parents and carers as a means of supporting compliance, particularly given that 16% of parents and carers identified that the non-compliance in their case related to the child refusing to comply. The need for child-inclusive practices was also emphasised by family law system professionals that participated in our survey of professionals, and they were both legal and non-legal professionals. More than 3/4 of these professionals agreed that more effective and widely available processes to support the participation of children and young people would reduce non-compliance and give rise to safer and more sustainable outcomes. And I'm sure we'll have an opportunity to consider these findings in more detail throughout the discussion.
Thanks so much, Ray and Rachel. Thank you very much for unpacking those findings and the very comprehensive methodology. There certainly are some compelling outcomes from what you just shared with us. So there seems to be a sense of distrust and fear in the system, and I'd really like to understand that a bit better. So we'll talk to the panel about that now. As we've heard, the contravention applications are not particularly common, despite the plethora of research undertaken, reflecting only about 8% of applications for final orders in parenting matters each year. So most parents and carers who experience issues with compliance don't use the contravention order regime, don't seek to legally enforce the breaches. Is this what we're hearing? How do they follow up on breaches? Let's try and understand what's going on. So turning to Michelle and Gabrielle, from your experiences working in the community legal service and legal sector, why don't parents take legal action in relation to contravention of their parenting orders? What do they do instead?
Yes, it certainly is my experience of clients aren't engaging with the contravention regime. And there's a number of reasons for this. One of the biggest reasons is a reluctance to re-engage in the court processes, particularly if they've been involved in protracted and highly conflicted court proceedings where they're under the microscope. They've been living with the stress of uncertainty in outcomes during court proceedings, that they do not wish to be involved or go through those processes again. There's also, I suppose, in their perspective, weighing up when looking at the remedies that are available through the contravention system, that the benefit of that is doesn't outweigh the emotional toll on them of having to re-engage in the court processes again. And I think Gabrielle's had similar experiences.
Yeah, so look, certainly the things, Michelle, you've raised are absolutely what we see and hear from our clients. I work with a lot of women who've been the victim of family and domestic violence, and one of the additional reasons they say to us they don't want to engage in the family law system again is a real fear of not being believed. Often the contravention that they're worried about also involves more perpetration of family violence, and they might have had a poor experience in the court the first time around, and a real sense that if they try raising these issues again, they're just going to get the same result. But additionally, just from a practical perspective, a lot of the clients I speak to aren't very familiar with, even if they do want to go back to the family court, they're not particularly familiar about what they need to do to actually raise a contravention application. Then once they're able to get some legal, it's actually really hard for them to get legal advice. Often if they've been assisted by legal aid, there's some confusion about whether or not they don't have a grant anymore. Can they go back to the same lawyer? If they're representing, if they were represented by a private solicitor, it's really common for them to have run out of money and just not have any funds to be able to pay someone again. So there's a real hurdle in terms of them being able to actually practically do anything in any event, even if they want to, and even if they've built up the courage to go back again, it's actually practically really hard to do.
And just as a follow-up, in your experience or experiences, the severity of the breaches, as Ray mentioned earlier, 80% of those 88 people who said that experienced those orders being breached without any follow-up, they were serious breaches. Is that what you're saying?
Yeah, and look, I think as Michelle said, it's really common for our clients to be really exhausted by this process. So by the time they're up to calling a lawyer again and wanting to get more advice, it usually is because it's something that they're really worried about and they really don't know what to do. And I think most of them are ones that would be really the higher end of contraventions, or ones where safety is a real issue for the kids and also for mum.
And so what do they do instead? What are some of the options, or some of the what's their recourse?
They live with it. I think that's you'll see them falling back into the patterns, I suppose, pre-court proceeding patterns of behaviour and the dynamics of the relationship, where you'll find one is just giving in or adjusting to the other to survive, basically, or to make it work. So it just becomes a matter of living with it until they get to the point that they can't live with it anymore. So it might be that there's been a build-up of consistent breaches till it gets to the point where really these orders aren't workable or practical anymore, or there's some other crisis children withheld, and that's more appropriate for recovery or along those lines more than a contravention application.
Also, I guess going back to the issue of some confusion amongst parents, often I find the women we speak to, they keep going back to the police. And it might well be that there actually is an issue that does need to be reported to police. The contravention involves both the breach of the family law orders and also it might be a breach of an AV, or it might be a new DV offence. But often how they're articulating it or verbalising to the police is about a breach of the family court orders, and they just get sent away, and we're really frustrated by the system and really confused about, well, I've got these orders, what's the point if I need to go back to the court to get anything done about it? And often they then have a very poor experience with the police as well, and then are hesitant to go back and report further violence. They often end up in really difficult situations and really unsure what to do next.
Okay. And just Ray and Rachel, turning to you, with, just following on from that, how does the court system monitor non-compliance of parenting orders?
Well, parties and the courts, they may include some provisions in the parenting orders that facilitate some monitoring. It could be that there is arrangements or provisions in the orders around providing clean drug screens prior to exercising contact, where there's also an order to require the party to refrain from being affected by substances when having the care of the child, or it could be that there are supervised time arrangements or supervised changeover arrangements in the orders, and they're to be facilitated by a children's contact service. So there is that mechanism that could be built into orders. There's also Section 65L of the Family Law Act that provides that the court may make an order for compliance with the parenting orders so far as it can be practicable to do so, supervised by a family consultant, or to have that family consultant assist the parties to comply. From the 1st of September, as you mentioned, Michelle, there is also the National Contravention List, which is intended to facilitate parties to make applications, contravention applications to the court, and to have a swift turnaround and streamlined turnaround. So to have their first return date within 14 days of making their application. So it's intended to have a better triage and assessment and response to those matters. But our research does show that there is a lack of mechanisms to monitor the implementation of parenting orders. So some of the suggestions that we had from parents and carers and from professionals included intermittent or periodic review of orders, case management post orders, therapeutic support for families post orders, and mechanisms to support compliance that were both within the court system but also outside of the court system. So what you were saying before about the police resonated with some parents engaging with the court system and engaging in our survey. What we also suggest is that any implementation of mechanisms that might follow should be evidence-based and they should be trauma-informed, and they should be implemented by professionals who have the requisite skills to deal with these families who are particularly complex, as Ray outlined when she was indicating the nature of our findings about this contravention cohort. And they also need to be mechanisms that are not costly for families and not open to misuse. So it's a very big challenge.
Indeed. And do you have any anecdotal evidence on how the list is working, or is that?
No, unfortunately our data collection, the data collection from court files and from both the survey of professionals and parents coincided with the introduction of that list, and so it will take some time to have some understanding as to the progress of that list.
Another project. And I think that's a lovely segue into children. And from what you're saying, a lot of the issues remain unaddressed, and monitoring is difficult. So some children are continuing to live with parenting orders that are not consistent with their safety and well-being. Heidi, I'd like to bring you in at this point. In your experience working in a therapeutic setting with families, how do inappropriate parenting orders impact children? What are you seeing?
Yes, in various ways. It means that there can be ongoing exposure to violence, whether that's through physical violence directly towards the children, or if it's verbal abuse from adult perpetrator, or systems abuse as well, ongoing financial abuse, use of the orders almost as ongoing abuse. And so that ongoing conflict, maybe not in all cases, but many, the historical experience already of domestic and family violence can continue, and the unpredictability that comes from that for young people. Those factors themselves are a part of the diagnosis of complex trauma. So that is a really key impact for many young people in this circumstance. And the key parts of the presentation of complex trauma involve dysregulation just across all experiences, whether that's all relationships and in their systems, like schooling or friendship groups. It also involves a lot of self-blame and difficulty with developing a clear sense of self, and a self that has self-esteem, and just general mental health challenges as well, and physical health challenges that come along with such strong dysregulation in the system. I think also in that circumstance, there's an impact where the with both parents and the relationship, it can be that the parents aren't necessarily supporting, or maybe one is supporting the parenting relationship between the young person and the other parent, but not maybe both ways. And that can create, for the young person with the adult perpetrator, ongoing fear and living in fear for at least part of their life, or week or day. With the protective caregiver, it can be that the relationship's still being undermined. The parenting role is still being undermined, which for the young person, that means it's really hard for them to get a sense of, I have someone who can help me, with all my big stuff, with all my difficulties and uncertainty here as well. It really undermines the protective caregiver to be in that role as much as they can be. I think as well that just sets up, and this is a really key part of complex trauma, is a foundation of relationships, or an image of relationships, of not being able to trust adults in particular, or trust others, to feel supported and safe with others. So that really sets up a really difficult attachment foundation for the rest of their lives as well. And I think as well another factor come across is that young people are voicing, or it's very clear that they're fearful of the adult perpetrator, but because of the legal complexities with the orders, or everything that's already been discussed, not a lot can be done there. And for the young person, that gives them a pretty early start of kind of the experience of feeling as though their voice won't be heard or isn't important, or just feeling really stuck. And that's another element of complex trauma.
Thank you. And just to clarify, your role within the system?
Yes. Yeah. So I'm a child and family therapist within a DV specific service that focuses on medium to long-term therapeutic intervention. We are, at Coronini Talera, we are a co-therapy approach. So protective caregiver has their own therapist, and each child in the family has their own as well. So there's individualised work, joint work. The whole system is, that we have eyes on the whole family system and the system beyond.
Thank you, because I think it's a nice segue, Donna, for you to let us know what your feeling and sense of the impact of these parenting orders on children have been. And you can introduce your role as well.
I'm an independent children's lawyer and working with Legal Aid New South Wales, and have been for some time. I pick up on some of the points that Heidi has made, in that, as well as Michelle and Gabriel, in that children also suffer from litigation fatigue. They are the centre of these, quite often, litigation, and they are the centre of the conflict and they feel that burden heavily. And whilst orders, at times I've had many children comment to me that whilst the orders are not exactly what they want, they're quite happy to live with them because at least the conflict will be reduced, if not gone. The pressure that has been put upon them as being in the middle of that conflict with ongoing litigation, and it not necessarily been the parents who have been actively questioning the children. It may not be as overt as that. However, they're aware of the conflict. They're aware of what the dispute is about, and quite often it's about them. So they do feel that high level of pressure, and they're quite often pleased at least the conflict is over. Okay, it's not what I want, but I can live with this because the conflict is over. But they are the families that need this intensive support service like Heidi's, who need to assist parents to reduce that conflict and stop making that child the centre of the conflict.
And Gabrielle and Michelle, did you have anything that you wanted to tell us about the impact on children where the contravention regime isn't used? Or
Yeah, look, I think just to add to it, look, I certainly agree with all the things that have been raised already. I guess the starting point is keeping in mind that the biggest issue we have is that children might simply be unsafe. And we do unfortunately see matters that children have been hurt following family court orders, either interim orders or final orders, because mums have had to comply and children have been in situations and scenarios where they really were unsafe. So I just think keeping that in the backdrop of everything, we're looking about their experiences, but also that they actually can be really unsafe.
Okay, it's not painting a very pretty picture. I think what we will, and now that we've established that only 8% of matters are taken to the regime, looking at when the contravention regime has been used and where there are presentations and issues around domestic and family violence and safety. Ray and Rachel, I think we might set the scene. Turning to when contravention applications are made, is there a gendered pattern to the parties who instigate litigation? What are we seeing here?
We did find a gendered pattern, and this was not only in relation to the contravention applications themselves, but also in relation to the primary parenting proceedings as well. So in the primary parenting proceedings, fathers were applicants in 67% of matters, and that's different to what we found in previous research. Previous research that was part of our evaluation of the 2012 Family Violence Amendments indicates that generally it's a 50-50 split. Mothers and fathers are applicants in equal proportions. So this is atypical, this pattern that we've seen in the primary parenting proceedings in this sample. When we go to the actual contravention application, what we found was that 74% of applicants were fathers. And it's also interesting to note that it's notable that most applications, so around 2/3, are dismissed, struck out or withdrawn. And so one of the themes that comes through both in the survey and interviews with professionals, but also the survey responses, particularly the quantitative, but also particularly the qualitative responses of parents, is that there's a tendency for the legal processes to become caught up in a dynamic of abuse, and it's a spectrum. It's not always at the very, very vexatious end of the continuum where you might have a clear application of the remedies for vexatious litigants, but there's also a more subtle manifestation where it is perhaps a persistent returning to court that isn't necessarily of a sufficient intensity to attract the application of the vexatious litigant provisions. So it's quite a complex set of issues there.
Very. Sounds like there's a nuance to that that we really need to understand. Rachel, did you want to add anything to that before I'm going to unpack that nuance with?
No, I think
with us
Ray's
solicitors?
highlighted the significant findings in respect to this question. It is a significant one and was somewhat surprising for us, I think, although in hindsight perhaps understandable considering the complexity of this cohort. Yes, it's definitely food for thought as to how we support these families in this cohort.
And 2/3, you say, of the application proceedings are thrown out.
Yep.
Interesting, isn't it? So
yeah.
very few are getting
That's right.
are successful.
That's right. And the comment that many of the professionals made was that applications could be poorly conceived and poorly evidenced, poorly set out, but also part of the issue around Division 13A of Part 7 of the Family Law Act is that there are it's basically what's known as a quasi-criminal jurisdiction because there are criminal penalties in there as well as civil penalties, which means that in order to invoke that jurisdiction, your legal material has to be developed with a very high degree of rigour and specificity.
And that's not always a penal response isn't necessarily what parties are seeking.
No.
It's often that they want the underlying issues to be dealt with and to have orders that better reflect the circumstances or the needs. So
Or the changing needs.
that's right. So it's a bit of a mismatch between what the contravention regime is intended to do and what families might be seeking to do. And that was both professionals and parents and carers that indicated that they were often seeking a variation to the orders or seeking to deal with those underlying issues.
Which seems to be the crux of your
Yes.
findings, is that tension
That's
between the conceptualisation of the regime and the best interests of the child and the complexity of the relationships that are reaching
Yes.
that point. So Gabrielle and Michelle, is the current system open to abuse? We have 8% of breaches getting to court or being followed through, and then 74% of those are males that are bringing those applications, and 2/3 of those are being kicked out.
Dismissed.
Dismissed.
Or struck out.
Struck out. What's that saying to us? Is the system, how's the system working?
Yeah, look, I think certainly it does create a space for further abuse. I mean, I work with clients on dealing with both ends of the spectrum. So the starting point, often I have clients when they've been the victim of further domestic violence and they're not able to take the contravention application, and perpetrators are often emboldened by that process because they're getting away with what they're doing. And then they'll also work with the cases where perpetrators are using the contravention application as a way to, I guess, continue to perpetrate coercive and controlling behaviours. And often there's a real fear from our clients about having to go back to court, and a real worry about often they're taking it more seriously and the compliance of the orders more seriously, and often the threat of it going back to court, or once the process starts, they'll often maybe agree to a compromise position that isn't really in the children's best interest so that they can appease the perpetrator or make things go away. Is that your experience, Michelle, that it's really part of that coercive and controlling?
Yeah, that's
behaviour?
definitely my experience, and it goes back into that pattern of appeasing and, what's going to make life easier if I'll just agree to that. And again, the contravention system's used as a kind of blunt instrument to get the clients that if you don't, comply, or if you don't strictly comply, then, this contravention regime's going to be utilised. And we see it in situations where, conversely, because the system can't be or isn't utilised, where a parent isn't taking up time or inconsistent, they can get away with that, which can actually cause, quite a lot of disruption for the child. It's not in the child's best interest at all when they're expecting a parent to collect them and they don't turn up. It can affect the live with parent's financial security if they've got to leave work unexpectedly or quite often because of that. But then worried about protecting themselves from that or changing arrangements because they've got the other party, very strictly saying you need to comply with these and strictly when it suits me, otherwise I can access this regime.
Donna, are you seeing
Um,
any systems abuse or?
yes, certainly you're seeing systems abuse in respect of some parties, that those ones that may not be doing it quite as much to be classed as a vexatious litigant, but certainly as a means of bringing that other party back before the court in relation to those issues as a punishment, really.
So the research was conducted during COVID, as you've explained, and as we heard. And so this provided a really unique opportunity for perpetrators for perpetrators of domestic and family violence, I should say, to use other forms of systems abuse. Are you able to tell us about this and whether or not the list has addressed any of these issues, Gabrielle? So
So
two lists in COVID, didn't we? Had the COVID list and the
So look, certainly, I guess throughout the COVID period, often really did see perpetrators really try and use the COVID situation to their advantage. It might be that they really kind of playing on what they knew would be mum's greatest fears. So it might well be that withholding a child and using that as a tactic to get what they want. It might be as a mechanism to find out more about what was going on in mum's household. It gave them more of what they would see as a right to say, well, who's coming into the house, who's your new relationship with, and trying to, I guess, have further control that environment. And I think overall, the issues of COVID is that our vulnerable clients were even more vulnerable because they were even more isolated and even less able to access legal services and support services in that period. And we certainly did see a real increase in our clients in really concerning situations. And well, I mean, at its peak, we probably weren't seeing it because our clients weren't able to get advice. But once things got a bit easier and they were able to contact us, that's really the stories that we were hearing from them. But we did see that the introduction of the COVID list did improve a lot of situations. That by the time things got further along, there was a bit more knowledge in the community, knowledge in practitioners about how COVID, how that was going to affect families and whether they had to comply or not comply with family court orders and things like that. Was that your experience, Donna? Or was
It certainly, I think the fact that the court set up a COVID list was an indication of how many matters they were getting into the system with this problem, and we certainly saw the same sort of thing, either withholding children or not returning children and using that as a tool against the other parent, which negatively impacted the children because they had their routines and knew the times they would spend with each parent, and so that was particularly upsetting for them. The COVID list, I think, was an excellent introduction by the court. Legal Aid's provided a mediation service and a duty service specifically for that list to try and help parents to try and resolve these issues quickly so that we didn't have that impact or we could minimise the impact on the children.
And that was all offered online?
That was offered online. Yes.
Yeah.
Yes, we had dedicated solicitors to it.
And that continues?
The COVID list I don't think continues at the moment, but it's certainly ready to be reintroduced should we have another set of circumstances occur again. But I'd have to say that the court acted quickly in getting that list up because of what they saw and the number of applications that were coming through.
And I have spoken to the court recently in terms of that list continuing. and sort of, I guess it's a post-COVID world in terms
Yeah.
of vaccinations and family trips overseas and passports and issues like that in terms of parenting decisions and orders. But what I meant was that does the legal aid support still sit around?
Yes, it does. We've always had a duty service to the court
Yeah.
and also an advice service. So that sort of offer, those services are always there. So whether it be the COVID list or any other list, they're always there.
And so turning to you again, Heidi, what did you see in terms of on the impact of COVID on children during the pandemic and the complexity and the uncertainty that Donna's talked about in terms of parents changing orders,
Yes, absolutely.
contravening them?
Yes, absolutely. It was certainly added another, really resonate hearing a lot of the points around the table, certainly added another layer of stress and distress for these families' lives. I think first and foremost, I think we've heard a lot of points that are focusing on the difficulty with decision making for protective caregivers because of the complexities involved. And so just this increased stress in protective caregivers, it being, the safe caregiver for a young person, seeing in most cases mum dysregulated or stressed, it was another layer where the young person was added to their stress and their dysregulation in their nervous system as well. So that in itself, just for young people who are already experiencing complex trauma, certainly amplified that and brought up more mental health challenges. I think as well, the isolation was another key element of it as well for the whole family. But for young people, of course, there was, seeking support. School, maybe, not so much directly, being at school, that structure and, being in that space was, removed for a lot of young people. So that certainly added to, less sense of routine and more dysregulation there. Fortunately, telehealth was in place for therapeutic intervention. However, that in itself came with its own challenges. We had a mix of experiences for young people using that platform. Younger kids, it was, it's difficult to do a lot of the play kind of based work over telehealth, but it was possible with some. For some, in the adolescence age, there was a mixture of, 10-minute sessions where a young person really just found it hard to feel safe in whatever environment they were in, or maybe they were at the adult perpetrator's residence as well. So that frequency of therapy also reduced for some. For some adolescents, they were able to feel more safe in engaging in therapy, so were able to actually open up more, and there were some really positive impacts of that. So it was a mixture.
You mean engaging online?
Yeah, engaging online.
Safer for them.
It felt safer if they were in a safe space at home, of course. But all of that came with its own challenges. We needed to make sure the young people were safe in there where they were doing therapy from, so no one could overhear them and things like that. I think, in terms of COVID and dysregulation of for young people, another factor that came up a couple times in just my practice experience was for the vaccines, where there was health-based content on the parenting orders where, a young person wanted to get a vaccine, but, one parent, protective caregiver generally was in support of that, but the adult perpetrator did not support it for whatever reason, and that was was an avenue to engage with the protective caregiver and more of that, coercive control would happen in that kind of context, as well as I think what has been mentioned, the dysregulation that came up from contact drop-off points was more, some of those like school weren't possible anymore, and the adult perpetrator using the restrictions or the lockdowns, I think a lot of that was open to interpretation, and so that was used in terms of, not necessarily complying with parenting orders. And for the young people, as Donna said, just that absolute disruption to routine on an already disrupted kind of life for them, moving between homes, one that's potentially unsafe.
So we are actually, thank you, going to move into the third topic of the webinar, which is focusing on children and young people having a voice in post-separation decision-making. And the research found approximately 56% of participants whose parenting matters were resolved after litigation and who had an independent children's lawyer appointed reported that the ICL did not speak with the children. Donna, can you tell us about how you approached engaging with children in your work and whether or not that's representative of
well, it's not
system?
representative of the sort of work I do, and certainly not representative of the cohort of independent children lawyers in Legal Aid New South Wales. It was very disappointing to see that the finding was that there was 56%. In my role, I also train independent children lawyers who are coming through, and that is one of the topics that we spend quite a bit of time on, is making sure that you meet with children at what stages in the proceedings that you meet with children, so that the children can know what is happening, that their voice is being heard, that they know the process that their parents are going through. They get an indication of when this process might be going to end. That's one of the most important things that they always want to know. It's certainly we spend time meeting with children generally after we've been appointed, before there's any significant event in the proceedings, and certainly meet with children after the final orders have been made. We're also cognizant of that in some matters the children are talking to lots of people at certain times. Police may be involved, JERT may be involved, DCJ might be, is the Joint Investigation Response Team might be involved, the Department of Justice, the Communities and Justice might be involved. So they're talking to lots of people at a time. So we always temper that with not trying to overload them, but certainly have them involved in the proceedings so they know the steps along the way. Every child is different. Some children engage and want to know what's going on. Some children don't. Some children find being the centre of that conflict really burdensome. So it's certainly our experience that we meet with children. We train our ICLs to meet with children. We give them training and tools about how to meet with children, and it's certainly something that's continuing to be promoted, and it's quite disappointing to see that that's the percentage.
Is there a national training
there is
in the mix, or is that something that's...
No, there is national training of independent children's lawyers. It's generally done state to state, but there will be a crossover. I know that in recent times I've had people from Queensland and Victoria, which has been really helpful to get a different perspective as to how the court operates in those different states. But again, it is promoted that you meet with children, and it's talked about as a requirement. So there's clearly a breakdown there where it's not been happening, and certainly Legal Aid has been looking at where that has been happening. Also looking at, as time goes on, independent children's lawyers, looking at best practice, particularly with the private practitioners who are acting as independent children's lawyers.
So just break that down for us, for those people who are watching who aren't part of the court system. So private practitioners.
The court makes an order to appoint an independent children's lawyer, and that's managed generally by Legal Aid New South Wales. It's operated by Legal Aid New South Wales. Not all matters can be kept in-house, and therefore there is a panel of private practitioners who have undergone the independent children's lawyer training, who take on acting as an independent children's lawyer on a grant of legal aid.
Okay, so that's how it's funded.
Yes.
So turning to Gabrielle and Michelle as the legal practitioners in the room, there seems to be a variation in practice from what the research has disclosed. Gabrielle, can you start and tell us more about this?
Yes.
And your experience with independent children?
Yeah, so look, I would agree that there is a variation in practice. From the outset, I'd like to say I've worked with some absolutely fabulous ICLs, and so there certainly are some really great ones out there and some really great models of how it can be done. But the statistic that was reported wasn't surprising to those who work in our service. We do hear it fairly regularly that the ICL hasn't engaged with a child in circumstances where you think that they probably would. The child's at an age where they would be someone that you would have thought the ICL would have met with them. And so really do see a real difference. And the case can be really affected by the quality of the ICL in the matter. And they play such an important role, obviously for the child, but also very persuasive in terms of in the legal proceedings themselves. So in terms of looking at how things could be improved, certainly it seems like lots of further resources to be allocated to ensure that ICLs. I'm not sure why. In some circumstances, they might not be meeting with the child, but I can guess it may well be that they're under resourced, and perhaps that could be something that could help. And obviously more training on perhaps specific needs of specific children. For example, more training working with First Nations children. But I think also what might be helpful, or how it could be improved, is if there was a clearer process when for parents to raise a concern. It might well be that they've aware that the ICL hasn't spoken to the child and they're not sure what's the most appropriate way to raise it. Often the parents I speak to are really conscious of not wanting to overstep a boundary, not wanting, they've been very aware that they shouldn't be talking to the child themselves about the proceedings, and they don't want to interfere, and they don't want to be seen to be making a point at the ICL. They're just wanting to make sure that the processes are followed. So sometimes the parents I speak to are very unsure about if something does appear to be going wrong, how to do it and how to do it effectively and sensitively. So that would be my suggestions based on the experience that we have.
Michelle, is your experience any different? Or
I was quite surprised to see those statistics. I mean, certainly I undertake work as an independent children's lawyer at the Aboriginal Legal Service, and did so when I was at Legal Aid with Donna. And yes, was trained very strongly about meeting with children, and to do always meet with children where it's appropriate. I do agree with Gabrielle, there is some variation in practice, mainly outside of legal aid, and I really think it comes down to resourcing issues and the value of how important the ICL is, or the role they play in the proceedings needs to be recognised, and the ICL system needs to be properly resourced, so we can ensure that there's not those variations.
Yeah, I think for such a critical component in response to the issue. My microphone has just popped off. I'll just hold it as we continue. Ray or Rachel, were there any findings from the research in terms of the ICLs specifically?
There were, and so yes, that figure that you mentioned before, and that has resonated in some part, but caused some concern in others, does indicate that there is a mixture of practices, suggests a mixture of practices in terms of that engagement of ICLs directly with children and young people.
And any policy responses in the mix, or?
Well, look, the Institute has previously undertaken research directly in relation to ICL practice, and National Legal Aid and the Legal Aid Commissions have undertaken work in response to that and continue to do so. And I think the issues that have been mentioned and supporting ICLs to upskill and engage with children would certainly be supportive in that regard.
And so I guess, we all know, and as the research has demonstrated, that children's needs change over time. And the research found that the family law system wasn't well equipped to respond to this. Has this been true for you? We'll go to the practitioner side of the table. And how could parenting orders be made more flexible, and what would you like to see for your clients, starting with Michelle and Gabrielle, and then we'll move to Heidi?
Yeah, look, it's a very difficult question to answer, because often in circumstances where we have family violence in a parenting matter, flexibility is one of the things that can... we spend a lot of time drafting orders so that they're not flexible, because giving perpetrators any room to move, often they'll make things really difficult. And one of the reasons why they're in the situation that they're in is that they haven't been able to resolve it themselves and actually need quite clear direction. In terms of answering that question directly, I think it's quite hard to do. I think part of what the issue is in circumstances where there's family violence and concerns for the child's safety or parent's safety, it's quite common still for orders for equal shared parental responsibility or orders for substantial and significant time or even equal time are being made really in circumstances where that's actually just too hard. And if you want flexibility in orders, you may well be better off allowing the parent who's not the perpetrator of family violence more freedom to make decisions without having to consult with the perpetrator of violence and going through hurdle after hurdle, round in circles, trying to negotiate something with a perpetrator of violence. So I think getting the orders right in the first place probably would ultimately achieve a better purpose than looking at how we can build more flexibility into the orders as they are.
Michelle and Donna, would you agree?
Well, I agree with Gabrielle in that we quite often draft orders which are very strict because what has caused the conflict between the parties has been the flexibility of the orders, and nobody has a crystal ball. We don't know what's going to be impacting children into the future for that particular family. So that's why the orders are drafted the way they are. In respect of, it's a hot topic about parental responsibility. My experience has been where you have one party who has sole parental responsibility, it causes a great deal of resentment, and then there are other tools that perpetrator of violence quite often uses as a result of that build-up of resentment by bringing the matter back before the court and causing that the victim further distress. But it's a very complex issue. There's no easy answer for the number of matters where sole parental responsibility solves the problem. On the other side of the ledger, it can cause the problem as well.
And Heidi, what's your sense of?
Yes, certainly a complex issue because I think children develop so much across their lives, or between their birth and 18. If we're thinking about this context, I think a big part, I can certainly hear why there's the difficulty with flexibility when at the time of making an order, but what is it going to look like in 5 years' time? And, we're not going to know that. But can that be looked at in 5 years' time or 1 year, whatever it may be? Because I think one key part of development that stands out to me is when children are younger, they are more egocentric, so they're more likely to self-blame or see themselves as the problem in the context of all the conflict. Whereas when they become older into adolescence, that's when they become more independent. They see themselves as separate to, at least partially separate to the relationship. And so they have a very different view and probably a very different voice of what they want or need at that time. So I think that's one way that development really has an impact. The answer to how to implement that is not one I have. But I think as well, practically a physical size, for particularly, children growing into adolescence, particularly male adolescents, their physical size, if there is any sort of violence or abuse at home, there can be more risk of escalation if they're at that age. And then again, that's a risk to safety. It might also change the young person's perspective of what they want and what they need or what is safe. So that's another consideration that we've seen in our practice. I think another one as well is relationships that the young person has across those years. The more, they might not have therapeutic support at the time of all of this being, all of the legal processes, but after developing more safe relationships, whether that's a therapist or within school or whoever it may be, they may be able to start getting a sense of what they do need or want. And so I think that changes over time as well. And what do we do with that then as well? So I think it's certainly a complex issue to summarise that.
Having some of the flexibility to incorporate those changing needs, as you say.
Yes.
And so the research has recommended that the family law system be grounded in child-centred and trauma-informed approaches. And you've mentioned some of the trauma that children are experiencing in your practice, Heidi. Ray and Rachel, could you unpack the recommendation? What are child-centred and trauma-informed principles?
Yes, so trauma-informed approaches are those that are based on understanding of the widespread impact of trauma, and it recognises the signs, the symptoms and the trauma in clients and families, and responds by fully integrating this knowledge into the practices and procedures and system responses. And it also seeks to avoid re-traumatisation. Professionals and parents and carers that participated in our research indicated that both child-centred and trauma-informed approaches to decision-making in parenting orders was a critical component. And that included that, you know, for example, if there were seemingly innocuous orders, considering whether they may actually serve to exacerbate harm that parties and children have experienced in the circumstances of domestic and family violence. So a trauma-informed approach was identified together with having domestic and family violence skills and training of professionals as crucial to avoiding that misidentification of people who are experiencing domestic and family violence as perpetrators, and avoiding penalising the protective parent in that context. And it also ensures that children and young people who have experienced trauma are identified, and the family law system responses are such that they ensure that the child or young person is safe and looks after their recovery. An approach with this sort of system design where there's a child-centred and trauma-informed approach will respond in a trauma-informed way, and that's really important for this particular cohort where we've heard about the fact that they're characterised by high rates of allegations or instances of domestic and family violence, and in the context of that child wellbeing data that we spoke about before, where 45% of the children and young people identified by the parents and carers were not faring well. So it's really important that we think about how we can incorporate that in our practice.
I'd just like to draw out of the discussion sort of a paradox that particularly the practitioners have drawn attention to, where we have findings and data that suggest a need for there to be a capacity for change and flexibility, and yet that very capacity would also be open to potentially abuse. And I think this goes back to a point that Rachel's been making around the need for the system to be very well equipped in terms of assessing and identifying the dynamics that are relevant in any particular situation. Expert domestic and family violence informed assessments, it gets down to being able to identify the families for whom flexibility would be a curse and those for whom it would be a benefit.
Absolutely. And I think, Heidi, what's your experience been? I mean, you'd be at the coalface in terms of understanding the impact of trauma. What does a trauma-informed or a child-centred trauma-informed approach look like to you?
Yes, there's certainly layers to it. And I think, part of that is a dynamic assessment, knowing that situations of domestic and family violence are changeable, looking at the patterns. I think that's a really key part of the assessment. I think another key part of the assessment for trauma-informed care is to recognise that a young person's experience or exposure to domestic and family violence, it can occur in terms of a wide range of experiences, from being directly, physically harmed to hearing it from 5 rooms away, all of those, or just being near the protective caregiver when they're experiencing the anxiety or the fear themselves. So I think recognising all of that is so important in terms of recognising a young person experiencing complex trauma. So those are 2 key parts of the assessment. I think as part of the assessment, but also the work from a trauma-informed approach is ensuring this whole system as much as possible is involved. So, that can be, working with, I know we've been talking about ICLs, and they, talking with practitioners who have been, have assessed the impact of the DFE and the complex trauma, being able to, before working with and assessing from a legal perspective with a young person, I found it really helpful in the past, from practice experience, to be able to share about the presentation of complex trauma and how to best work with that young person with that specific presentation, because the range of experiences and presentations is broad. And so I think as well, and another thing is I've been, asked for direct recommendations as well that have been considered, so that the whole trauma assessment has been included in that consideration. So I think that those are very important factors. As part of the system as well, I'm not talking about every part of the system because it can be often a lot of system, but for parents as well, being able to help the parents, educate parents on trauma and what they can do, which can often be quite little things to help increase predictability, help with co-regulation, regulate themselves, and that can really be a benefit, if we're talking from a therapeutic lens. Seeing a young person 1 hour a week is very important. That's important intervention, but there's, I don't know how many other hours are in the week as well. So being able to use the systems to be able to educate and, apply what's being done in session outside of session is so vital where possible. I think getting more specific, working directly with a young person, a trauma-specific informed approach has various elements to it, but I think really key parts are recognising that a young person may not always present as their developmental age with trauma. They can present as years older or years younger, and that can inform how best to work with them so they feel safe and, held. I think in their communication can vary as well. It can be a lot of verbal or non-verbal communication, other forms of communication such as drawing or art as well. And just understanding what their tolerance is for, close relational development. There can be a lot of fear around developing relationships. So it might be, there have certainly been some clients where I start with a 5-minute therapy session and we build up to an hour over, quite a block of time. So recognising kind of tolerance for that time so a young person doesn't become too dysregulated. And that's another fearful experience to add into their experience. So there's some factors to consider from different layers.
Thank you, Heidi. And Donna, just, briefly, because we're going to run out of time soon, do you have any, what informs your practice, like what child-centred principles? Or
Certainly identifying those matters where you have trauma and working with counsellors about how we speak to children in those circumstances, whether we do speak to children in those circumstances. There's certainly some matters where there has been that level of trauma where I will talk to a counsellor first before I make that decision about meeting with the child. That counsellor can also assist me with how I can focus my discussion with the child, what the child can take on, what to bring up, what not to bring up. So it's certainly identifying those matters where the trauma is, but also working with the counsellor to best engage with that child.
And we've been talking about trauma-informed approaches and touched briefly on child-centric approaches. Rachel, did you have any more points that you'd like to raise in relation to what the research found around child-centric approaches before I ask each of the panel members just to very briefly identify their approach?
Sure. So in the context of the family law system, it's looking at both professionals and parents, considering the parenting arrangements through the lens of the children and young people, and to also more effectively acknowledge that capacity that children and young people have to participate in the decision-making process, and then operationalising that. So thinking about, well, what are the safe and genuine and effective opportunities to allow children and young people to participate in this process. So, we've talked today as well about how that's important from an evidentiary perspective because we're having evidence before the court directly from children about their views and experiences, particularly in the context of experiencing domestic and family violence, and then that in turn can help us to support outcomes that address their safety and well-being.
Turning to you, Gabrielle and Michelle, What is your final comment in relation to mechanisms the family law system should put into place to be a more child-centric, focused environment, and also to include young people's participation in parenting order decision-making or conversations?
Well, making it more child-focused in dealing with parents, it's about making sure that they are, say, looking at it from the child's perspective and talking about it in a way that it's the rights of the child, the rights of your child to have this relationship with the other parent, or it's the rights of the child to have this, and take that focus away from what their rights or what they might be seen as fair, and also having a look from the child's perspective. And there's a common example that I use about, if a shared care arrangement, if you had to live in two households, how stressful would that be for you? If you had to remember everything and knowing that, if you forget something, you're not going to be able to get it and it's going to create this huge conflict. So really getting those parents to start thinking about what's going on for their child in their world. And from an ICL perspective, we've discussed again is why it's so important to meet with the child, because you really need to know understand more about them and what is going on for them in their world, and are they a bit more shy and reserved, what are their likes or dislikes. So you kind of get the idea again when you're drafting orders that it's going to work for them.
Thank you. And Gabrielle?
I think really what I'd like to add to it is there's not one thing that we could do to improve the system. I think it's really about all the aspects of the system working well and being focused on the child, and having every practitioner working in the family court, every ICL, every decision maker being really across those dynamics of family and domestic violence, being really across issues that might affect First Nations children or families who have particular needs. And so I guess really increasing the expertise but across the whole system. So everyone that's involved, including our family report writers and people like that. And hopefully that would give you a more child-centric approach.
Donna, what's your...
I would agree with Gabrielle. It's about funding quite often, about making sure that people are appropriately trained and properly trained. I think there has been certainly a great step forward from years in the past where we are much more child-focused than what we are. And I pick up Michelle's point in that getting the parents to look at it through that child's lens is really difficult. It's an easy thing to say, but very difficult to try and achieve.
An aspiration.
Yes.
Ray or Rachel, did you have a final comment before? I'll invite Heidi, and then if you'd like to think about whether or not you would like to make a final comment, we'll throw to questions.
Yes, I resonate with all of those points. I think it's certainly the system, because a child engages in so many elements of a system. They have so many components. So I think having people trained in complex trauma and the recognition of ongoing training would be beneficial, because the complexities in complex trauma are quite broad as well. So I certainly resonate with all of that, and also helping parents to recognise their value in providing as much predictability for young people as possible amongst all of the distress and conflict. So, that I really don't have anything more to add than that, but the system is vital. Yeah.
Absolutely. Well, we might throw to questions now, because we've got a few that have come in. And thank you all for your questions in the lead up to today, but also throughout the webinar. Gillian asks, and Ray, this might be one for you, Ray and Rachel, given the applicants for contravention being 74% male, was there a gendered breakdown of the contraventions applications that were dismissed? I'm unable to remember the specific statistic with regard to how many contravention applications are dismissed, but I'm just wondering how effective the court is at recognising when applications are a form of coercive control or systems abuse. So was there a gendered breakdown of applications that were dismissed?
That's an interesting question. I don't think we did a gendered breakdown of dismissed, struck out and withdrawn applications. But it's interesting to note that in the cases that proceeded to a substantive judicial resolution, a breach was upheld in 48% of those cases, but then a reasonable excuse was also upheld in 14% of those cases, and then it was found that a breach did not occur in 23% of cases. So overall, where matters proceeded to a substantive resolution, only 6 were upheld, and we found that there was a gender difference in terms of the proportions of cases where a breach was upheld, and women as contravention applicants were more likely to be successful than men as contravention applicants. But that was a relatively subtle difference. So it was there, but it was, I don't want to overstate the significance of it. But thank you for the question, and that's certainly an interesting way we could look at the data.
Thanks, Gillian. And James asks, on the issue of independent children's lawyers, do you have any thoughts on ensuring the lawyers have the necessary skills to communicate directly with children, perhaps even through training provided by children and young people themselves? Ask you that one, Donna.
We do have, as a part of the training, about talking to children and talking about how you might do that in a child-focused way and an age-appropriate way, talking about just simple things that you might have. I know in my practice I have what are called story cubes, and there are a set of cubes with different pictures on them, and you throw the cubes, and you ask the child, is there any picture there that you can tell me about your family? Just those sorts of ways, so that you're not directly asking children to focus or asking them about the conflict in their life. When I meet with children, I'm very much aware what I'm asking the child to do is come in and let's talk about your dysfunctional family. I'm very much aware of that. So we do look at and train at looking at different ways we can do that. I also use a simple map of the world on just a plain piece of paper that I've printed off, and I ask them to tell me who's in your world and who's in your bigger world, and talk about it in those sorts of terms. So we do that training, and we reinforce that training.
Donna, did you have sorry? Thank you, Donna. Heidi, did you have a comment on?
I think I really resonated with the part of that question that spoke about kind of having young people or people with lived experiences become part of the training. I think there's increased research across multiple areas in psychology anyway, one of them being complex trauma experiences or children in care, informing research at least. So I think there would be I think that's certainly an area to look into, is how they can be a part of, people with lived experience, a part of training. I think that would be so valuable. Yeah.
Absolutely. Are variations of parenting orders made? And if so, why or why not? Ray or Rachel?
Yes, variations of parenting orders are made, and that's one of the more common outcomes where a contravention application proceeds. It's also one of the outcomes that's more commonly sought, and that particular aspect of the regime is subject to a best interests analysis because it is a parenting order, and so the court has to have regard to whether or not the variation that's sought is in the best interests of the child concerned. So certainly a variation seems to be both from the perspective of parents and professionals, a sensible outcome in parenting, in matters where there are concerns about the way the parenting order is working. So that is definitely, something that occurs and is seen to be very useful. And it would be perhaps interesting to hear from the practitioners as to your experience with variation.
that's a very common outcome when a contravention application is filed. It's a very common outcome that then follows an application for variation. That's the next logical step. And whilst some people may find that frustrating, at the end stage, if it brings about a variation of the orders that is going to work for this family, that is a good outcome, in my view.
Yeah.
Michelle?
As I said, we actually have so little matters where clients have actually engaged with the contravention regime that we're really looking at those ones where a variation is not, it's become so bad that you really need a substantial change to the orders, and it's really a whole new set of proceedings that we're looking at rather than a variation to the orders.
Yeah, that's certainly the experience of myself as well. The variation is, one of those situations where more likely to be looking at helping someone or actually take something further, but we are much more likely to make the application as a fresh application, change in circumstances, as opposed to a variation that's tied in with a contravention application, because it ends up being the focus is really then more on what needs to happen next as opposed to what's happened in the past.
Yeah. We might have time for one final question. Miranda asks, how many of the applicants for contravention applications were self-represented litigants, and whether there was a link to success or dismissal where they were self-representing?
In relation to representation, in relation to contravention applications, 31% of fathers were unrepresented and 34% of mothers were unrepresented. That actually contrasts with the primary parenting order proceedings where we had much lower levels of lack of representation at 13% for both fathers and mothers. So I think the point that emerges from those data is that one of the things you hear discussed about contraventions is that it's one of the issues is around lack of representation and the fact that proceedings weren't well run. And these data tend to suggest that whilst that makes a contribution, it's not the bigger part of the story. In relation to self-representation and the extent to which that is linked with higher or lower levels of matters being struck out, dismissed or withdrawn, I actually can't remember off the top of my head.
Well, I don't know that we do have.
I don't know that we did that analysis.
Because
yeah.
the numbers would be quite small at that level as well, so it may not be.
Yeah.
That may be one reason why we didn't report it, but certainly some good suggestions from these questions about whether interrogating the data.
Absolutely, and thanks, Miranda, for your question. I think that's something that the researchers can definitely take up. Look, we are at the end of our time for today, so I just wanted to take the opportunity to thank you all very much for participating. Thank you, Ray and Rachel, for the report. I encourage the audience to pick it up and read it. It's a fabulous final report. And as I said earlier, it sits alongside the first report, which was published earlier this year. The webinar recording will be available on the ANROWS website, as I said earlier. The exit webinar feedback webinar would be great if you have an opportunity to do that now. And for any researchers tuning in, if you're working on projects addressing violence against women, you can submit your project to the ANROWS Register of Active Research, otherwise known as the RA, on our website. And I'd also like to ask you to keep your eye out for an upcoming webinar with AFES and CFCA on the 30th of November. Unpacking this research but from a different perspective. It is titled Parenting Orders Research on Compliance and Enforcement and Insights from Practice. So it will be a different panel, but it will be looking at the research further and interrogating further. So if you didn't get an opportunity to ask a question today, you might at the next webinar. So I'd like to thank you all again for your time, and thank you to the audience. Michelle Robinson, on behalf of ANROWS, thank you and goodbye.